How do you pronounce your first name? Duracia or Duracia
Yeah.
Williams? And Mr. Kindler is here and the state's attorneys are here.
A Texas courtroom hears a serious probation violation case as a woman with multiple prior convictions faces a third-degree felony, a charge that could lead to years in prison. The defense points to possible mental health issues and asks the court to consider treatment instead of prison, arguing her behavior may be triggered by fear in past experiences. But prosecutors highlight her long criminal history, repeated violations, and new charges, including assault on a police officer while already on probation. Now the judge must decide whether to give her another chance, or finally end probation and send her to prison.
As you know, there's a motion to revoke unadjudicated probation in this cause number 25 CR 425. Does the defendant waive a formal reading of this motion filed on December 12th of 2025? Can we proceed in summary?
Yes, Your Honor.
First thing we're going to do, there was an issue raised by the defense on the defendant's competency as to whether she was or was not competent to proceed with her proceedings. Ordered Dr. Edgar Pond, licensed psychiatrist, to evaluate the defendant. He is prepared, and we've received a report dated March 20th, 2026, finding the defendant to be competent. I'm going to call this report Court's Exhibit 1 on this date.
It's here to stay.
And it will be made a part of the record in this proceeding without objection. Okay, it is received. And we can proceed in summary.
Yes, sir.
Raise your right hand, ma'am. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion to revoke unadjudicated probation filed in December of last year in this cause number 25 CR 425 states that on July 9th of last year, 2025, you were placed on 10 years deferred or unadjudicated probation for evading arrest or detention with a motor vehicle, a third-degree felony. Is that true?
Yes.
One states you committed the offense of assault of a public servant on or about October 19th, 2025 in Jefferson County, Texas, in violation of your probation order. Is that true or untrue? Did you, have y'all talked?
I think she's previously heard. No,
this is the only motion here, and there's nothing on the face of this. I would write on.
Judge, I wrote on mine that she and her pleas are not true on January 30th.
Okay.
And
I wouldn't put that. Well, I thought, what are we doing? Is she admitting to anything here? And what's
she didn't admit to anything back on January 30th. We conducted a hearing.
okay? What are we going to do today? Is she going to admit?
She's been found competent. I think the issue of competency was raised prior to a disposition.
Well, there it is.
She's been declared competent, so I mean, we proceed to a disposition at this stage.
Well, that's what we're trying to do. So what are we going to do?
Your Honor, my understanding is that the state presented all of its evidence on January 30th. I had Officer Lonick testify about the proof as to the assault that he occurred to him, as well as the fleeing. And that was where the state limited its evidence on presentation on January 30th.
That was January 30th, right?
January 30th, counts 1 and 2. We have video evidence that showed that the fleeing was, in this lawyer's opinion, obvious. And then there was the body cam footage that showed where she struggled and kicked him in the appropriate areas alleged in the assault.
Yeah.
And if necessary, we can retrieve the video that was placed in evidence to remind her of the evidence. So after I passed the witness and Mr. Kindler was cross-examining the defendant, he was raising the issues about her mental stability, and out of caution, Your Honor, ordered the examination. She's been determined to be competent. I would ask that the court
pick up where we left off in that hearing.
I would ask that the court make findings of true as to counts 1 and 2 and proceed to punishment.
Well, what do you have to say?
Disposition. I think that's accurate, Your Honor. And then if you might refresh my recollection about what occurred, I think while the report if I could slip over and argue that some, a lot of the court does find it to be competent, there are some indications of mental health issues that may militate in favor of more lenient treatment with the disposition of the NTRP.
Okay, then the court will find that based upon the earlier hearing and this hearing and presentation of evidence concerning the defendant's competency, where the defendant is declared competent, that the defendant pleaded true to, well, she didn't plead true, that the court found, based upon the evidence presented, true to allegations 1 and 2 by a preponderance of the evidence or greater, that the defendant committed the offense of assault of a public servant on or about October 19th, 2025 in Jefferson County, Texas, in violation of condition 1 of her probation order, and that she committed the offense of fleeing a police officer on or about October 19th, 2025 in Jefferson County, Texas, in violation of condition 1 of her deferred or unadjudicated order. The court not only deems it meets the threshold for preponderance of the evidence, but the court found it true beyond a reasonable doubt in each of these cases. So what shall we do? Defense?
Well, Your Honor, many times,
Thank you.
I think when people are faced, which some people are faced with an interaction with law enforcement, they react in a way that doesn't seems to defy explanation. I would observe that Ms. Williams is on probation for a previous offense of evading, which of course involves the action of law enforcement. Now, let's interact with law enforcement in a way that has resulted in this NTRP being filed. I think, I don't know that
How much time?
the competency exam goes into her mental health history rather extensively. She's in a position to kind of maybe indicate to the court why she seems to be triggered by interaction with law enforcement. I would observe too during the incident now that's given rise to the allegations of the NTRP, there was no contraband found in it, or there really seemed to be no rational explanation for her actions, other than just she has, I don't know, I'm not an expert, but PTSD and a triggering event dealing with law enforcement. I'm not trying to excuse it, just maybe trying to contextualize it, and she could maybe tell the court what was going on in your mind if you had seen that with the officer.
No, I blacked out.
She's mumbling. I can't hear you.
I blacked out. I really don't even remember. I'm scared of the police. I'm scared of the
Are you?
police.
Is that the root of your troubles, you think?
I believe it is.
Nobody knows more about you than you. Let me ask you, have you ever been convicted of any other criminal offenses?
Yes.
Yes.
Okay. How many times?
I don't know.
You don't know how many times you've been convicted of a crime?
Twice.
Okay. Is that your,
Violence, yeah. Twice.
is it?
But he did be out here.
No, I'm talking about for any misdemeanors or felonies that are above a class C misdemeanor, above a traffic offense. Crimes.
Probably 5 times.
Sir, ma'am,
5.
5, 6 times.
It's closer.
Well, we're not playing horseshoes. This is real life. You should know better. You should know more about you than, well, I shouldn't have to correct you on that one. This should, but that's 2, 4, 6, 8, actually 9 times. 9 times, 9 convictions. What does that say? That's from 2011 through 2024, and now this one you're looking at on a probation. I mean, I stuck my neck out on this one with this criminal history, and it's assault, prohibited weapon, switchblade, and brass knuckle or something. Assault, family violence, resisting arrest, failure to identify, driving while intoxicated, resisting arrest and search. Those are all, they're misdemeanors, but they're still, you were arrested and then you had to serve jail time. Every one of those one was 2 days, one was 9 days, and the rest were 60 days or more. Anyway, that, and evading arrest has consequences because this is, you have 3 resisting arrest convictions before this one. So, evading or resisting are in the same family. They have consequences. All right. He has 83 days credit here. This is a 3rd-degree felony. So what should we do?
Judge, my suggestion is a 5-year sentence. I think it's warranted by the criminal conduct prior to her being placed on probation. It's additionally warranted because of the offense. It was the felony offense that was committed that Your Honor saw the video on. And frankly, I still remember this officer testifying now 2 months ago. He showed great amount of discretion with this individual. He could have charged her with the same offense. She was on probation and chose the misdemeanor offense of fleeing instead. I believe Your Honor even commented on the record about that, just the length of time that went with here and then the number of officers that it took to get her just to comply speaks volumes.
Right.
Then if we go past that, and this year she's had 10 different violations that she's been written up for in the jail that she just doesn't want to follow rules. I don't believe putting her back on probation is going to be beneficial for anybody. Certainly not for Jefferson County. I think the 5 years would be appropriate.
Defense.
Your Honor, I don't disagree with Mr. Ham's characterization of the officer's conduct in this case. I think he showed remarkable discretion both in interacting with the defendant and in his choice of charges to file. So certainly I don't take any issue with the officer in this case. He went above and beyond to try to treat Ms. Williams appropriately.
What are you suggesting we do?
Well, without hearing from the probation officer, I don't know if they're willing to continue to supervise her. If there's still a chance that maybe with some sort of mental health intervention, you may be able to mediate the issues that she seems to have occurring with law enforcement. That would be one thing. If the court is inclined to revoke her, I would ask the court to consider taking into consideration mental health issues and consider a lower end of the statutory range.
Anything from probation?
No, sir, we just didn't have a chance to really spend any time with her. I mean, she got on probation in July. She got a new charges in October.
Okay.
But during that time, she never told us anything about any mental health issues.
Yes,
So we'll address that.
Yes, sir. Anything you want to add, ma'am?
I mean, I asked my probation officer, but I was in Houston, so I don't know who I should have talked to. The one in Houston or the one, I mean, it was kind of confusing.
She may have been reporting in person here.
Well, the important thing, the first thing you have to do is not commit another crime, which you did twice, along with the other 9 prior convictions. Court finds that these are new. What are you going to do with those?
She probably has sufficient time served on
Which one's Judge?
the misdemeanor.
The October 19th.
All right, so I have a felony offense that's pending for the assault on peace officer. And in misdemeanor court, we have the fleeing offense.
Is that where it is?
Yes, sir.
Right, I will find that if nothing further, there is sufficient evidence supporting this motion to revoke unadjudicated probation and grant it by preponderance of the evidence or greater as the court finds allegations 1 and 2 proven true as the defendant is admitted these violations, and the court earlier in the hearing found them to be proven true not only by preponderance of the evidence but beyond a reasonable doubt that assault on a public servant and fleeing a public officer criminal violations were committed by the defendant on her probation. Thus, that is a violation of her probation order. Her probation is hereby revoked. Earlier in this case, the defendant had pleaded guilty to the 3rd-degree felony of evading arrest or detention with a motor vehicle voluntarily, knowingly, intelligently. There was sufficient evidence supporting her guilty pleas from State's Exhibit 1. Her guilty plea from State's Exhibit 1 admitted her plea hearing to support her guilty plea to find her guilty beyond a reasonable doubt. I had deferred any finding of guilt at this time. The court is moving forward based on her violations of probation. I now find you guilty beyond a reasonable doubt of that third-degree felony you had pleaded guilty to back in July of last year. And I find you guilty beyond a reasonable doubt. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You will be given credit for all the time you have served in accordance with this case. Please do that. All of those. Anything else? That is all.
We may be in another sense of that.
On who?
On this way, so it's all, I'm going to talk to her about that.
What are we doing on Amanda?
She's not here.
I'm gonna call the jail. I feel like she made it 3 minutes this morning.
Okay, so on Amanda Nolan, we're going to pass on that.
Yes.
Okay.
By the end of the hearing, Judge John Stevens makes his decision clear: probation is no longer an option. With repeated violations and new crimes, the court sentences her to 4 years in prison. Do you think the judge made the right call after so many prior convictions? Or should mental health have played a bigger role in this decision?